Yes, sir.
Sir, I am here, sir. Sir, what about Chief Guest? Chief Guest have joined or not, sir? Okay, okay. Yes, sir.
I'm there, sir. I'm there.
Okay.
Yes. As per your convenience, I'm ready, sir.
Shalini, ma'am.
I'm here, sir. I'm here.
Okay, sir. Good morning to one and all who have gathered here. On behalf of Nehru Institute of Engineering and Technology, I welcome you all for today's webinar on Intent to Do More but Compelled to Do Less, presented by Mr. Prahlad Jadhav. Before moving into the presentation, I request our beloved participants to mute their mic at the time of presentation. The platform will be open for queries when the presentation gets over. Feedback link will be available in chat box when we are about to end the session. Now, I leave the time to Dr. Shalini Pakyam Kamala, Professor and Head, Department of SNH, Nehru Institute of Engineering and Technology, to deliver welcome address.
A very pleasant good morning to you all. Every time when programs or webinars are conducted from library, it gets its special attention because of the very vibrant department handled by the very active librarian, Dr. K.R. Sendil Kumar. During this lockdown period, he has conducted many programs in different areas, like different educational tools for academicians and all e-resources about different library usage techniques and many other useful methods. I think now his attention has turned towards copyright. Very high profile resource persons, always he conducts a webinar. He enriched us with a lot many programs with high profile resource persons, and this time also SAR has arranged such a program which is national webinar on intent to do more but compelled to do less, library Jugaad in terms of copyright. We are very happy to welcome the resource person of this webinar, Mr. Prahlad Jadhav, Associate Director, Library, Ketan and Co. Sir has a Paka CV. When we go through that, we could understand that during this lockdown alone, he has conducted a minimum of 50 programs. That is, he was the resource person for 50 programs. And in few things, he acted as a solo performer. We are very eager to learn from you, sir, and happy to welcome you, sir. And I'm very much delighted to welcome our management representatives, Dr. P. Krishnadas, Chairman and Managing Trustee, and Dr. P. Krishna Kumar, CEO and Secretary of Nehru Group of Institutions, both in Kerala and Tamil Nadu, which has 22 institutions, right from medical college, law college, arts and science college, few engineering colleges, B schools, international school, and kids schools too. And Nehru Institute of Engineering and Technology is one among the main colleges in which we have a Paka library, which is called PK Das Knowledge Fort. And it is associated with National Digital Library of India. It is today we are having this program. And I'm happy to welcome our principal, Dr. P. Maniarasan of Nehru Group of Institutions, Nehru Institute of Engineering and Technology. He conveyed his wishes to us, and I'm very much happy to welcome our Principal in charge, Dr. P.T. Vijayaraj Kumar sir, who's going to give us presidential address as well as introducing our chief guest. And it's my pleasure to welcome all the participants. Many of us are continuously giving us supports in taking part all of our events, and we are very happy to have you all together in this platform. Happy to welcome you all. Thank you. And one more announcement is we heard the news that Google Meet may support one hour period. Time period is restricted, it seems. If in between any connectivity trouble occurs, kindly rejoin using the same link. Thank you all.
Thank you, ma'am. Now I call upon Dr. P.T. Vijayaraj Kumar, Director, Department of Management Studies, Nehru Institute of Engineering and Technology, to give presidential address and to introduce our resource person.
Thank you. Most respected resource person, Mr. Prahlad sir, respected principals, faculty members, librarians, and dearmost participants from various institutions. A very good morning to all. First of all, I want to appreciate Dr. K.R. Sandil Kumar, our librarian sir, for arranging this webinar. He is organizing national and international webinars in various aspects for all the people or the learning fraternity, faculty members, even for students also. Today, we are very much happy to be part of this webinar organized by our PK Das Knowledge Port, NDLI, and Nehru Institute of Indian Technology, Coimbatore. They are jointly organizing a national webinar on intent to do more, but compelled to do less. Library Jugaad in terms of copyright. So copyright is a concept, a very important concept in the modern world in these recent years. It's in all aspects. It may be like business or brand name or book name, innovations, journals, publications. In all the aspects, copyright is very also. Everywhere, copyright is very important. Today's topic is very necessary for all of us. I hope this topic will be useful for all of us. So we have an eminent personality with us to share his ideas, his knowledge, and experiences to all of us. We are waiting to listen your message, sir. At the outset, on behalf of the Nehru Institute of Engineering Technology, we once again welcome today's resource person, Mr. Jadhav, Associate Director. He is Associate Director of Library, Haitan and Co, Mumbai. He is also a knowledge manager, a librarian, and information professional. Over 17 years, he has more than 17 years of experience in the same field in the national and Indian companies. Mr. Jadhav is currently working as an associate director in library and knowledge repository at Haitan Company. It's a leading corporate law firm in India. Previously, he worked with UPG College of Management, and Mr. Jadhav is passionate about technology, information, and knowledge sharing, and its impact on both the corporate and the academic sector. His core domain areas are a strategy for data information management, libraries and data management, knowledge management to personal knowledge management, search strategists for information retrieval, and so on. Some smart tools, e-content development, IPR and corporate plagiarism. In all these areas, he is very much familiar. Mr. Jadhav graduated in commerce from Mumbai University in the year of 1999, and he has completed his post-graduation Master of Library and Information Science in the year of 2005 from Department of Library and Library Science, Mumbai University, with the second rank. And he has completed postgraduate diploma in digital library and information management from the prestigious Tata Institute of Social Science University. Mr. Jadhav also qualified UGC NET in November 2017, and he has registered his PhD, which is under the primary University of India at IGNOU in library science, and he got so many awards. In 2020, he got a National Librarian, Dynamic Librarian Award 2020 from National Library Day from Levon Technologies Private Limited because of his work done in COVID-19 period. And Haiton and Co. Professional Development and Branding Award 2019 and 20 as a Performance Appraisal Announcement Committee. Gratitude Award from different working LIS professionals in Maharashtra on account of World Disability Day in 2019. And he got on Lifetime Achievement Award in 2016 from AVS Sanstha Abarnath in World Disability Day in 2016. So he's a right person, and he has handled more than 50 sessions during this COVID-19 period. He's also the resource person for national and international seminars, conferences, and also is also the resource person for the government education department. So such a wonderful and great resource person is with us. He's ready to share his knowledge and his ideas, his experience with all of us in the area of copyright. So on behalf of our college, Nehru Institute of Engineering Technology and Nehru Group of Institutions, we welcome you, sir, for this wonderful webinar. And I want to appreciate all the organizers, all the people, those who are behind this program. I wish you good luck. Thank you.
Thank you, sir. Now, I request our resource person, Mr. Prahlad Jadhav, to start the presentation. Sir, the platform is yours.
Thank you so much, madam. Thank you, Director, sir. Thank you, my dear friend, Dr. Senthil, for giving me this golden opportunity to talk in front of such a wonderful audience. Dr. Senthil, can you just allow me to share my other screen? Yes, yes. I got it. Thank you so much, sir. Thank you. So just give me a second. I'll just share my screen with you, all of you. Can anyone confirm my presentation is visible to you? Yes. Thank you so much for a wonderful, morning to one and all. Definitely today is a national webinar, and but I want to say there are a couple of participants who are not from the India, but they are from the abroad. So I just want to mention that it is not a national. Now, under the belt of Dr. Senthil, it is an international. It become an international. So friends, today what we are going to discuss, intend to do more, but compelled to do less. See that lines give you lot of meaning to you. This webinar is organized by the NDLI and PK Das Knowledge Force under the banner of Nehru Institute of Engineering and Technology under the kind leadership of Dr. Senthil. As briefly introduced by Director Sir, myself Prahlad Jadhav, working as an Associate Director in one of the important law firm of India, that is Ketan and Company. I'll just give a background of my firm because it is really required. When Dr. Babasaheb Ambedkar was writing the constitution, he had a team of 10 people. From that 10 people team, one of the person name is Dr. Devi Prasad Ketan, right? So he is the founder member of the Ketan and Company. He was started the firm in 1911 in Calcutta. Then slowly and steadily, firm flowed from Calcutta to Bangalore, Delhi, and Mumbai. We had a future plan also. We are proposing our setup in Chennai, in Hyderabad, in Goa, and in Mauritius. It is in the future plan. So to start the topic, definitely we should quote something. Yes, the quote for today is that the beauty of copyright law is to protect you. Actually, it protects you, and then it provides you the opportunity to honor the other. It means what? First thing, it protects you, and second thing, it will provide an opportunity to you to honor other. So it is really important. It is really important. And my subtitle is Library Jugaad in terms of copyright. Why I am using the Jugaad word? Yes, many times it happens. Our director, our principal, our vice principal ask us, please scan the copy and give it to me. Definitely, at that time, we are going to infringe something copyright, but still we manage something and we do Jugaad on that. So that's why I use this library Jugaad in terms of copyright. See, that person is carrying two kids in a bicycle, which is Jugaad. So that's why we have to think innovative. We have to manage the legal component also, and we have to provide service also. That's why librarians should be very smart. Library community should be very smart in terms of handling copyright. So I'll start with this joke. A teacher, she asked to write a essay on my dog, and in that class there were two boys who were twins. And when they submitted their essay, so teacher just explained that, kids, your essay on my dog is exactly the same as your brother's. Did you copy from him? So one student replied, no teacher, it's about the same dog. So it means copying is not illegal, but you have to be give justification. You have to give reference. You have to give credit. So in that way, if you are doing something, then definitely it is not harming you. It is not any illegal. On 26th, yes, on 26th of April, every year, world celebrate World Intellectual Property Day. Yes, on 26th of April, every year, every part of the country, every part of the world, they celebrate World Intellectual Property Day. Why we are giving so much importance to the intellectual property? Why? See, if I didn't lock my house, the thief will come and they will just rob everything. Just like that. Whenever I go to my office in the morning, I take my bicycle, I go to the parking and lock it. Why? Because I had a fear that somebody will steal my. So the same way, we have to be very careful in terms of our intellectual, whether we are protecting or not, whether we are keeping safe or not. That is really important. Otherwise, if you don't give that much importance to your intellectual, then it will be very difficult for you to protect. And if you don't protect, then definitely somebody who are not in a good frame of mind, he will steal your intellectual. So we have to be very careful. So jokes apart, see, one thief, he had stolen a car, and that person whose car it is, he found shortly. And inside it, that car, a apology message was there from the thief, and he had given 3 tickets to of cinema to that person as a compensation. That person, the car owner, went to cinema with family. When returned home, he found the whole house is stolen. And message say, may the film enjoyed you. It means what? Whenever, if you're giving free hands, see, you have to be very alert. You have to be very alert. If you're creating something very intellectual, then you have to be very alert. Otherwise, it will be very difficult for you to, to get back your own things. So, my dear friends, whenever you're writing something, whenever you're putting something in your from your intellectual, you have to be put in a very protected way. See, the managing director explaining the statement, profit and loss account statement to the other directors. What he had mentioned that, see, that the blank space, what he had mentioned, unfortunately him when he left. The other director who had left the firm, he had taken his own intellectual. See, that is the power. If you have your own intellectual, and if you want to leave somebody, then you can live with your own intellectual. It means what? There is a company, and in that company, chemical company has certain patents. So if I want to leave that company from board of directors, I can leave. I can take my patents with me. So that is the power of IPR. That is the power of intellectual property. So jokes apart, I was in the schools when this jokes happens. Best memory of school life. Not copy, notes copy कर रहा था, तो समझ में नहीं आया, तो मैंने उसको पूछ लिया, ये क्या लिखा है बे? तो उसने बोला, जो समझ में आ रहा है वो लिख, बाकी ऐसे ही डिजाइन बना दे. So this is the exact joke of copyright. People doesn't care what they are copying. If they copy, if even it is wrong, they copy even it is mistake. They blindly copy. So you have to be very careful. If you are taking some words, if you are taking some others material, you have to give a proper quotation. You have to give proper message to the in the reference. Otherwise, it will be termed as a copyright infringement, and it will give a bad impression in front of your audience. So you have to be very careful in terms when you are going to copy something. You have to be very careful. So friends, when I start a day in the morning, in the early 6 o'clock, it's the IPR starts from that day. The start from early day. How? See, IPR daily life. जिंदगी के साथ भी जिंदगी के बाद भी. What is that? That is called LIC, right? Life Insurance Company. Then हक से मांगो. What is that? प्रिया गोल्ड. चाय के साथ हम बिस्किट खाते, हक से मांगो प्रिया गोल्ड. दाग अच्छे हैं, तमिलनाडु में बहुत सारी बरसात हो रही है, शायद मेरा पेड़ फिसल के गिर जाओ, तो देन आई कैन यूज दाग अच्छे मतलब सर्फ एक्सेल. इसको लगा डाला तो लाइफ जिंगा डाला. आमिर खान, टाटा स्काई. So this is the way IPR is associated with us. It means what? For a single person, IPR associated with his activities on a day-to-day basis. It starts from early in the morning till the end of the day. So it is very important. So for example, early in the morning, if I'm getting toothbrush with the Colgate, it means Colgate had a patent. And when I'm going to the bed, the good night is also IPR product. So we have to be very careful regarding the IPR. Why IPR is important? Why? Because it will differentiate original and duplicate. See, Adidas and Adidas, both the things, when you pronounce, it will look like same, but it is changed. It is different. So we have to prove what is original and what is duplicate. And the company owner, they need this power. That's why IPR is very important. Another example, Tide, TIDE and Tides, TIDS. See, the China-made product Tides and the Indian is Tide, TIDE. The another, Puma and Roma. See the difference. The original is Puma and the duplicate is Roma. The another example, Hike and Nike. So these are the very basic example. So this you can imagine why we are giving so much importance. It is really important. If you don't give right importance to your intellectual, then there may be a chance your intellectual can be theft. And it is really important for your day-to-day activity. You have to give importance. Then I'm talking about the intellectual property assets, IPR, rights. So assets, basically, I'm a commerce graduate. There may be other person who are commerce graduate. What assets? Assets is divided into two parts: tangible assets and intangible assets. Right? What is tangible asset and what is intangible assets? Dr. Senthil Kumar, I'm audible. It's session going on. Good. Okay, thank you so much. If there is disturbance, please let me know. If I am going fast, also let me know. Right. So what is fixed asset? In a common sense, fixed asset means what? I will just share my next slide. What is fixed asset? See, fixed assets means physical existence. That value of that assets get depreciated. Easier to sell off. It can be destroyed by fire and natural calamities. This is called tangible assets, right? Now I am going to tell about asset, fixed asset. That is tangible asset. Physical existence, value of assets get depreciated, easier to sell off, it can be destroyed by fire and natural calamity. Then, my friends, what is on the other side? The coin should have two sides. One is tangible asset, another one is intangible asset. Then what is that intangible asset? Goodwill, yes. Patent, yes. Trademark, yes. Copyright, yes. Brand, yes. Know-how, yes. So it means what? Intangible asset means do not have any physical existence. Value of the asset gets payback. Yes. If I have a royalty, then definitely every will I'll get the royalty. If I had copyright, definitely I'll get copyright, registration money from them. So they are not that easier to sell off. It means what? It is not easy to sell off like physical assets, intangible assets. If you're comparing intangible assets with the physical asset, it is not that easy. But there is a one strong point. It cannot be destroyed due to business failures. Yes, for example, COVID. We are facing this problem from 7 to 8 months. Still, business are sustaining. Yes, because they had a very good goodwill. They had a very good competition. So that's why they are sustaining themselves. So that is really important. So my next slide will be talk about the intellectual property. It is a category of property that includes intangible creations of human intellect. It is a category of property that includes intangible creation of human intellect, assets that can be bought, sold, mortgaged. Yes, my patent can be mortgaged, my patent can be bought, my patent can be sold. Even my patent can be exchanged. Even my patent can give us a license. So this can be only happen with the intellectual property. So that's why it is called as a intellectual property. So I will just go in a deep with a story time. Yes, one engineer who had left earlier firm and joined another firm. But he kept having a regular lunch with the boss, the earlier company boss. And he thinks that he is a very hero, that he is gathering competitive intelligence from the boss. But the result of this lunch meeting, what happened? The person, the person who joined the new company, the company had lost three major bids in 14 months because in the time of lunch he was sharing all intellectual to his boss, and the boss is taking care of that, and he has played that role, and he had, he is able to got that bids because he had all the intellectual from that person. So, my friends, whenever you're sharing something about your job profile, institution profile, be careful. Otherwise, there are people who can take the advantage of yours. So, it is really important. You have to be very alert in terms of intellectual. If you're sharing something, then it is really important. You have to be very alert. You should know what you're going to share, what you're going to not to share. And if you don't do the problem, right, that intellectual property. Another story I want to tell here, all these immigrant scientists from the European countries, they are from the European countries, they got the invitation from their home countries to speak at the seminar or serve as a paid consultant. These scientists from European, they work for another countries, but these countries, they are inviting them, come and talk, speak in our seminar, serve as a paid consultant. Why they are calling them? Because they think this country, those who are calling, they think so. This kind of intelligence gathering as cheaper than a research and development. It means you can easily gather the intelligence from the scientists. It is cheaper as compared to the R&D. So, my dear friends, definitely, if I'm working in America and my countries are getting calling back me, so I have to be very careful because I have to be loyal. Whenever I'm working, I have to be very loyal. What I'm going to share in public, what I'm not going to share in the open house. We have to be very careful. So it is really important. So whenever you're going for a talk, whenever you're going for a talk, seminar, you should be very careful what you're going to share. If you are not careful, then there may be chances of theft. Okay. My next slide will be on focusing on the IPR in the classroom. You may ask question, why in the classroom? Why students are important for this? Yes, my dear friend, it is because they are our real assets nowadays because they are our real assets. With the increasing focus on innovation, research, and cross-border collaboration, need to learn about the IPR to safeguard their invention has increased among the students. Young researchers need to know more about IP rules and rights. Yes, because they are our young generation. Because they are going to build our economy. So they should know what is IPR, what are their rights, what are the legislations, what are the legal framework. They should know for us to promote IPR, to create awareness of IPR among the students. So my suggestion to integrate IPR in the classroom. Yes, they should integrate IPR in the classroom. Right? So IPR, if IPR is there, then we need to be protect and promote. So how? Yes. Why to protect and promote? Why? There is a big question. Why need to be protect and promote IP? Because progress and well-being of the humanity. If you want to do good for humans, then it should be progress. It should be protect. So first reason is progress and well-being of humanity. Right. Then the second is what? Legal protection. Yes, my dear friend, legal protection of new creations. Yes, if there is a new creation, then the legal protection should be there. We have to be very careful. And the third and important reason, what is that? Economic growth creates new jobs and industries. So these are the three basic reasons why we need the IP should be promote and protect. First one is progress and well-being. Second one is legal protection, and third one is economic growth creates new jobs and industries. So who are going to regulate this IPR? Who is taking care of the IPR? Yes, IP convention are administered by the World Intellectual Property are administered by World Intellectual Property Organization. Why in short it is called as a WIPO. Yes, in every part of the world, WIPO is taking care of the intellectual property at the international level. So how did it play their role? We will see in the post presentation, right? So, categories of IP, intellectual properties. Intellectual properties is divided into two parts. First one is industrial properties. Yes, my dear friend. First one is industrial properties. The second one, which is really important for today's session, that is copyright and other relating rights. So, intellectual property is divided into two types. First one is industrial properties. Second one is copyright and other relating rights. Right. So, what is industrial properties? Friends, according to me, according to the IPR in India, industrial property is divided into industrial design, patent, trademark, trade secrets, geographical indication. There are other also, but I had quoted here the major one. Even plant bridges rights is patent, trade secrets, trademarks, and geographical indications, and other are also there. So these are the important under the industrial properties. So copyright, yes. The symbol indicates this symbol indicates copyright. Please do not steal it. The lady is mentioning don't copy. So it is very simple. Copyright means what? Don't copy. If you are copying, then you have to give credit. So I will explain copyright in a short story. Mr. Y, an artist, decided to make a short film. He has a very good story, and he made the film. The film is based on Indian swag. So he added a song called Swag Se Karoge Sabka Swagat. While uploading the film, he received copyright notice that you cannot upload a song, the said song, because it's Sabka Swagat. While uploading the film, he received copyright notice that you cannot upload a song, the said song, because it is already copyrighted. So this is the advantage of the copyright. If you have taken copyright properly, then nobody can steal your idea, steal your intellectual from for their purpose. So copyright, it is an intellectual property, right? It is an exclusive right for the creators, right? And it is for literary, musical, and other artistic property, right? It is an exclusive right for the creators of what? Literary, musical, including what? Films, sound recording, computer software, etc. So what are the legal framework? Why I am talking about the copyright? Is there any legal framework? Yes, for the protection of traditional beneficiary of copyright. For that is individual authors, composers, or artists. So you have to be very good. These are the legal framework in terms of copyright provides for legal framework. Moreover, it is also important for the investment required for the creation of work. So why it is required copyright legal framework? Protection of traditional beneficiaries, right? Then individual author, composer, or artist. Then another reason, that is investment required for the creations of the future. So that's why there are two conventions which is play an important role in the IPR. What are the conventions? The first convention I want to name here, that is Paris Convention. Yes, it was notified in the year 1883 for the protection of IP, intellectual property. So I am talking about the copyright. Again, I mentioned about the Paris Convention. Is there any convention for the copyright? Yes, my dear friend, there is a convention, and that convention name is Paris Convention. Bern Convention. What name is Bern Convention? It is actually made for a protection of literary and artistic work, and it was notified in the year 1886. Convention de Bern pour, actually this is in the some other language. So it is mainly for the protection of literary and artistic work, and it was notified in 1886. So where does copyright exist, my dear friend? Where it is copyright exist? Friends, copyright exists in different category. Are listed one by one, one by one, one by one. So what are that? For the copyright exists for literary work? Yes, copyright yes exists. Then copyright exists for the computer program? Yes. Copyright exists for the artistic work? Yes. Copyright exists for the film? Yes, my dear friend. Copyright exists for the dramatic work? Yes, very much sure. Copyright exists for the musical work? Yes, definitely it is. So copyright exists for the sound recording. So this is the where copyright exists. So now we will check one by one all this category how copyright works for them. First one is literary work. Example of literary work: school textbooks, judgments, head notes, commentaries. Who are the author? The writer. The writer of that work is the owner of the that work. So writer. The term of copyright: lifetime of author plus 60 years. It means lifetime plus 60 years. So literary work, what are they? School textbooks, judgments, head notes, commentaries. Then who is the owner? My dear friend, owner is the writer. Term of the copyright, lifetime of that author plus 60 years. Lifetime plus 60 years. Then second category, dramatic work. Yes, example of dramatic work, drama, play. It excludes cinematography film. Yes. Then who is the owner? Creator of the work. Who create that work? It is the owner. Then what is the term of copyright? Lifetime plus 60 years. Lifetime plus 60 years. The another category, what is another category? That is musical work, right? Example, musics and includes any graphical notation. The song is not musical work, right? Owner, creator of the music, yes. And term of copyright, it is lifetime of author plus 60 years. So this is applies in each way. It applies varies from different category. So in music work, lifetime of author plus 60 years. Then the next category, what I want to tell, what I want to discuss here, artistic work. So what is artistic work? I will tell you in short. A painting, work of architecture, work of artistic craftsman, author, artist of the work. In case of photograph, it is a photographer. And in terms of copyright term, lifetime of author plus 60. In terms of photograph, if artistic work is photograph, then it is 60 years from the year subsequent to the year of publication of the photograph. So this is copyright for this artistic work. So you have to be very careful in terms of dealing with the copyright. What type of category you are dealing, or what type of regulation it requires, or what type of term it requires. You have to be very careful. My second category, next category is sound recording. Means a recording of sounds on any medium from which sounds produced. Means a recording of sounds on any medium from which sound produced. Author, producer. Then term, the term is 60 years from the year subsequent to the year of publication of the sound recording. It means what? The producer of the work is the author, and the term of copyright is 60 years from the year subsequent to the year of publication of the sound recording. When it is published, from that point, it is 60 years. So it is very clear. You have to be, if I'm working for a media library, that time, such type of category is really important for me. And I should know all this legal component for my user purpose, for my office purpose, for my institution purpose, right? Then the next category is cinematography film. Example, films, animation films, video films. Producer, my dear friend. Who is the author? Producer. Term, 60 years from the year of subsequent publication. Yes? Yeah. Hello? Should I continue, sir? Acha, that one. I'll try. It is not moving. Okay, I got it. I got it. Now it's fine. Thank you, sir. Thank you so much. So now the current category is broadcast reproduction rights. I'll just check whether I had covered the earlier presentation or not. Earlier slide. Oh, so film we had covered, right? Producer of the work and 60 years from the year subsequent to the year of publication, right? Then we will go to the next category, that is broadcast production right. It means communication to the public by wireless diffusion or by wires, one or more form of sign, sounds or visual images. Who is the author? Friends, broadcasting organization. And what is the term? It is very much clear, 25 years from the year of broadcast. If I broadcast it today, it means from today, it will be till the 25 years. And the last category, if I'm not wrong, from the for the copyright, that is performance rights. Yes, the who is performing, for example, actor, musicians, jugglers, a person delivering the lectures like me, snake charmer and dancer. These are the performer. Then performer, who is the author? Performer of the work. Term 50 years from the year of performance. Today, if that person perform, from today, it will be till 50 years. So I had covered each and every category, which is really important for the copyright. Now I will talk about the who is the owner. भाई ये मेरा घर है, भाई ये तेरा land है, ये तेरा plot है. But in terms of copyright, who is the owner? In the copyright, I had already mentioned about the category who is the owner. But again, I will just revise you. The owner is author of the work, writer, composer, artistic, producer, and performer. It means whether that owner has the right. अगर मैंने कोई जगह purchase किया है, तो I had some power. Like that, whether copyright owner had the rights. Yes, my dear friends, copyright owners had two types of rights. So you should know your rights. If you had some copyright material with you and you are the owner, then what is your rights? My dear friends, there are two types of rights. How many types? Two types of rights. First right, moral rights, and the second right is economic right. Just a second, I'll just take a sip of water. So moral rights and economic rights. So what is moral rights and what is economic rights? We'll just check of authors, composer, and to determine the indication of the author name, right? Right to preserving the integrity and author honor, popularity. Right. This is called moral rights. Then what is economic rights? Yes, I can make a duplication, I can make a replication, right? Even I had a right to make that work available to the public. So this is fully transferable. This is fully transferable. See, I mentioned here, it is fully transferable. So these are the rights for the copyright owner, and everyone should know what are their rights and how they can defend themselves. So we had talked about the copyright, how to protect, who is the owner, what are the rights. Then suppose if there is how it can be theft. That concept called as copyright infringement. What is called as copyright infringement? If somebody taken without your permission, that is called copyright infringement. Unauthorized use of work without permission of the owner of the work. That is now termed as a copyright infringement. What it includes? Sale, hire, offer to sell or hire. You can, if it is distribute copies for commercial purpose, again it is copyright infringement. If it is exhibits in the public without the owner permission, then copyright infringement. Import in India any infringing coffee, then definitely it is the infringement of copyright. So be careful. Whenever if you are taking others' works, you have to be very careful. Otherwise, you will be in the copyright infringement. So how to avoid? Is there any Ramban for this? Yes, my dear friend. There is a Ramban, Ram Shastra, which is available. How to avoid copyright infringement? We are the librarians and we know the innovative way. Yes, we can use public domain work that is copyright free. Even we can use some part of the copyright work under the fair use clause. So this is very clear. If you want to avoid copyright infringement, try to use public domain work, try to use fair use component. So what is that? So fair use versus public domain. Work used under fair use are still covered by the copyright. That work definitely it is covered. If you're using fair use work, definitely it is covered in the copyright. But the work in the public domain are not covered by the copyright. It is not covered by the copyright. In fair use, part of the work may be only used for the education, research, news reporting, criticism. In public domain, allow for entire work to be changed, adapted to other media or reproduced with no legal consequence. In public domain work is there. You can allow entire work to be changed, adapted, right? And to other media or reproduced with no legal consequence. Then permission needs to be obtained to sell or distribute in terms of fair use. If you're working in the fair use, then permission needs to be obtained to sell or distribute. Then permission is not needed in the public domain. If you're using public domain work, public permission is not required. Then in fair use, the credit must be given to the original creators. Yes. And in the public domain, credit must be given to the original creator by citing the source. So these are the exact difference between the fair use and the public domain. So we have taught everything about the copyright. But is there any legal component who defend the copyright? Yes, my dear friend. The act which was initiated in the year 1957, the act name is Copyright Act 1957. Yes, and it is amended 5 times till date. In 83, in 84, in 94, in 1999, and recently in 2012. In 83, it was amended because of broadcasting technology and reprographic technology. In 84, it was amended the technology like printing and recording of broadcast program. In 94, it was amended to deal with the piracy of medical textbook, and in 1990 they amended to confront of the trade expense. And in 2012, it is when it is considered as a most substantial amendment, and why we will discuss here. So India is a very mature country in terms of legal, and so that's why they had amended, they had upgraded that old act time to time to protect the owner. So Copyright Amendment Act 2012. Yes, it was passed on 8th June 2012. The Copyright Amendment Act is significant in terms of challenge posed by the internet. Yes, the major problem caused due to internet. So that's why 2012 amendment is a significant. So in this amendment, there are some welcome changes and there are some worrisome changes also. So first we'll check what are the welcome changes. The welcome changes, I will just share one by one, which is available with me. Commercial renter, yes. Amended in the section 2 after clause 5F. They had inserted FA in the section 2 and mentioned as a commercial renter. Commercial renter means you can refer to a synonym frame which includes the rental, lease, or lending of awfully acquired copy. If I had a DVD library, then I can rent that DVD to my other colleagues on a proper copyright way. There is no issue, there is no harm. Then the important component in 2012 amendment, that is fair use, which I am talking about. But before going to that, what is fair use? If you have to consider that is fair use, then that fair use should obey with four principles. What is? First one is purpose and character of your use. It should be very clear. Then the nature of the copyright work. It should be very clear. The amount, how much you are going to copy, that is also clear. That should also clear. And the effect of use upon the potential market. If there is any negative, any commercial effect, it is required that you have to be very careful, right? Then, fair use in general context. If you ask me, what is the section 52, subclause 1, clause A. A fair dealing with any work not being a computer program for the purpose of. You can use work under the fair use for the purpose of research, criticism, or review, or reporting of current events and clause is valid under the fair use clause, right? Then, if you are doing for digital work, yes, for the purpose of electronic transmission or communication under subsection 1, clause B, it is allowed. If you are providing electronic link, access to integration, yes, it is allowed under subsection 1, clause C. It means section 52 under subsection 1, clause B is for electronic transmission or communication. Section 52, clause subsection 1, clause C is for the providing electronic links and access to integration. Another important is the 2012, yes, notice and takedown procedure. New clause C of section 52. They had inserted new clause. What is that? Section C. Written complaint received from the owner. If that work you had published and if you received the written complaint from the owner, it means you have to be remove that. And if you remove, there is no problem. There is no legal complications. But if you don't remove, then there will be a problem. And if no order issue, अगर आपको किसी से कोई notice नहीं मिल रहा है, if the owner had not sent any notice to you, then you can continue with that. You can continue with that information on your for your website, for your blog, for your paper, right? So this is the very important amendment they had made. There are other also. If it is something called the judicial proceedings, yes. If I am using some work for judicial proceeding, it is allowed under section 52, subsection 1, clause D. Reproduction of any work for the purpose of judicial proceedings and reporting of, yes, it is allowed. So under the fair use, I can do this. I am in the legal firm, so it is very important for me. And I have already informed this to my lawyers, so they are using such type of benefits under the copyright. Then the next thing, which is really important for education institute activities, yes, you are working in the education institutes. If you are doing any activities under the education institute, it can be considered under the fair use. Where section 52, subsection 1, clause J, the performance in the course of activities of an educational institute. For example, there is an open gathering and I am playing a Chak De movie का वो last scene 60-70 मिनट है आपके पास, 70 minutes है आपके पास. So it is allowed and it is considered as a fair use under the education institute's activities. My friends, we are from the library, so If there is anything, yes. If you are doing digitization of library, yes, it is allowed. Where section 52, subsection 1, clause N allow you to do these things. Public library to store an electronic copy of a work. If it is already as a physical copy of the work, storage shall be only for preservation purpose. Yes, if you're doing for the preservation purpose, then definitely it is allowed under fair use, digitization of library, section 52, subsection 1, clause D. Clause N. Then technical drawings, yes, draftsmen, engineers, yes, it is allowed, section 52, subsection 1, clause W. It means making of a three-dimensional object from a two-dimensional object for the technical drawing, it is valid. There is no copyright issue. So you have to be very careful. All these changes all these welcome changes are in 2012 amendment, right? Now, see how Indian government is thinking, in a broader way. When they are amending 2012, they had not leave any stakeholders. Even they had considered the person with disability, how they are covered under this amendment. So it is very useful for them. Section 52, new clause ZB has been added. Section 52 under subsection 1. It provides what? Adaptation, reproduction in any accessible format to facilitate persons with disability. It is mainly for the education purpose. It is mainly for the education purpose only. Education purpose and research purpose. These rights are available to any person or organization those who are working for the benefits of person with disability. So this is the way you can use fair use under section 52, subsection 1 and new clause is ZB. Another important change is, yes, those who are doing any beneficiary work for the physically disabled person, then they should have a compulsory license for them. And it is inserted in the new section 31B. They had made that the person, that organization, those who are working for the physical disabled, they should have a compulsory license. Another important changes amended, which is come in 2012, that is digital right management, insertion of new section 65B. Why? What is that? Insertion of new section 65B. Any person who knowingly removes or alters any right management information without authority, it means electronic right management information has been removed or altered without authority, shall be punishable with imprisonment 2 years and fine also. It means if you are doing purposefully, then definitely you will be behind the bars for 2 years and fine also. So DRM, we are in the digital component, we are in the digital media, so DRM play a very important role. So these are the welcome changes. Is there any worrisome changes? Yes, my dear friend, there are some worrisome changes. In Copyright Amendment Act 2012, what is the worrisome changes? Copyright term, yes, the duration of all copyrights are above the minimum required by our international obligations. If you are comparing with the international obligations, then the duration is very high and we have to be careful. Sometimes it is very difficult to trace the original author. So for that purpose, it is a worrisome changes. Just like welcome changes are acceptable. Worrisome changes give tension to us. But there are also some missed opportunity. What are they? What are the missed opportunity? Yes, 2012 amendment, they had missed fair dealing guidelines. A detailed fair use guideline is missing. They had not provided. Then education exception. What stakeholders are assuming, they want some more education exception, but it was missed in 2012 amendment. Then when they are communicating to the public, the government, when they are communicating to the public, they got lag. They had not reached each and every stakeholder of this education domain. And they had not involved, they had not considered each and every aspect of the internet intermediary. So these all are the missed opportunity. So if the next amendment will come, that time they will take care of this. But right now, they had missed in 2012 amendment. So this is the missed opportunity. So friend, another missed opportunity what they had missed, the users and small creators. Yes, they had left out of the discussion. Who? Users and small creators. Who are they? Libraries and librarian myself. They are not involved. The librarians, consumer, historians, teachers, students, RT activists, independent publishers. They had not taken their consideration while they are doing amendment. While they are doing amendment, they should consider all the small creator also. So they will get actual feedback how we are facing. So this is called Copyright Amendment Act 2012. My dear friend, I will just highlight something which is really important. That is called Marcus VIP Treaty equal to the Copyright Amendment Act 2012. What is that? Marcus VIP Treaty. More than 75 WIPO members have signed the treaty. It was adopted on 27 June 2013 at a conference organized by WIPO in the city Kingdom of Morocco at Marrakesh. Right? India has become the first country. I'm very proud to say I'm very proud to say India is the first country who had ratified the Marrakesh Treaty, and it was approved in 30th June 2014. See why I am giving importance to the MVIP Treaty. Now I will just compare Marrakesh VIP Treaty and Indian Copyright Amendment Act. What was there? In Marcus VIP Treaty, currently there is total 76 countries available, right? So why I'm giving importance to the MVP treaty? Yes, because according to the MVP treaty, if a librarian, if he is scanning something for the benefit of the physical disabled people, it is allowed under MVP treaty, right? But the treaty got notified, adopted in 13, sorry, right? 2013. But as an Indian government already notified in Copyright Amendment Act, they had already made provision for the disabled person in 2012. See, it means what? We are thinking on one step ahead as compared to the world. So I'm really proud. The provision which made in the MBAP treaty, it is already made in Indian Act, in Amendment Act 2012. So that's why I'm telling, I'm really proud that Indian government thinking ahead as compared to the world. So the current position of this treaty is 76 countries already adopted this treaty, and you can take other countries' work and make the changes and give it to your physical disabled people. The other part of copyright, that is plagiarism. Yes, so we'll start with the jokes. Stealing from one person is a plagiarism. Stealing from many person is a research. So this is a short joke, but I will tell you the concept with the story. A and B are the very good friends. So A, B still cat of A, and without informing him, he was taking that cat, but suddenly A caught the B, and B got a lesson that what the lesson? You can just take somebody cat without asking for permission. It means you can take others' work, but you have to take the permission. You have to take the permission. Now my second story. He take the cat and went outside. His friends asked whose cat it is. So Bill tell the lies. It is mine. That is wrong. Here again, B got the lesson. Tell the truth to the people. If you are taking something from others' work, mention that I had taken this story, I had taken this image, I had taken this word from other persons, and mention in the reference that this is from so and so person. So the third part of the story, what he had learned and shared to the world, okay to borrow the others' work, it's your story, as long as you first ask the permission. Second one is give credit to the person. It means you can take, but first take the permission. And the second one is give credit to the person. So plagiarism, the word plagiarism comes from the Latin word. It is called kidnapper. It is in short, it is called kidnapper. मैंने किसी को kidnap कर लिया. That is called plagiarism. So plagiarism, what is a plagiarism? In other words, it is a copying information and not giving authors credit. In a simple term, it is the act of presenting another works or idea as your one. किसी और का मेरे नाम कर दिया. That is called plagiarism, and you have to be very careful. So what is the definition? According to Merriam-Webster dictionary, the act of using another person's words or ideas without giving credit to that person, that is plagiarism. And according to Pearce and Shield in 2013, page number 1, plagiarism is a specific form of cheating, right? And is generally defined as a presenting someone else's work as your own. So this is called plagiarism. Why plagiarism is important? Why we are talking plagiarism in the session of copyright? Why it is important? Because it is considered as a theft, it is considered as a cheating, and it is considered, if you caught, then the grading will be 0. You can be fail also. So that's why plagiarism is really important for education domain, for the research domain, for the teaching community, for the commercial unit. Plagiarism is a very important. So what can be considered as a plagiarism? Presenting another work without as your own. Using words and idea without giving credit, this is plagiarism. Not using quotation mark, this is plagiarism. Giving incorrect information about the cited source, this is plagiarism. Copying such large amount of ideas overall that the majority is not yours, that is plagiarism. So what is there any types of plagiarism? Yes, there are near about 8 to 10 types. So I will tell one by one. First, I will explain how people are got in that. Somebody may be accidental, somebody may be intentional. Accidental also called as unintentional. What is accidental? It occurs when researcher or writer use the words or thoughts of others but fail to give credit and quote unknowingly. They fail to give the credit and quote unknown. This is called accidental, or it can be named as a unintentional. Then intentional, purposefully we do. We copy but we don't give the credit. That is called intentional. Intentional. Then what are the excuses people are giving why they are doing plagiarism? What are the excuses? अरे my teacher expect too much यार, इसके लिए मैं कॉपी कर लेता हूँ. Higher college, higher एकदम very reputed college. That's why I do the copyright. Copy. कोई पकड़ता थोड़ी है. It's okay if I don't get copy. कोई नहीं पकड़ता है. चलो कर लो copy. Then अरे सब तो करते हैं यार. मैं किया तो क्या है? Everyone does it. My parents expect. My parents is expecting A plus. So that's why I'm copying. So this is the excuses generally students, people, researchers give to their higher authority. Then types of plagiarism. Clone. First one is clone. Submitting another one. Then second one is control C. Significant portion can be copied with the help of control C. Then find and replace. Changing the keywords and phrases. That is also plagiarism. Then remix. Pre-phrases. Pre-phrases from multiple sources. 10 source में से एक paper बना लिया. That is plagiarism. Recycle. Own work without citation is also plagiarism. It is called as a self-plagiarism. Then hybrid. Perfectly cited without. But perfectly cite कर रहा हूँ, उसको use ही नहीं कर रहा. This is also called as plagiarism. Then mashed up. Mixes copies material from multiple. Right? Mash कर देते पूरे एक जगह पे लाके. And उसमें से सिर्फ थोड़े से को we will give the reference. That is called mash up. 404. Non-existing inaccurate information. मैंने use नहीं किया, फिर भी गलत information दे रहा हूँ. मैंने use किया है. Then aggregator. Proper citation. But the paper contains almost no. मैं proper citation दे रहा हूँ, लेकिन use ही नहीं कर रहा हूँ. Retweet include proper citation, but relies too closely on the text original wording and structure. If you are retweeting, you have to give reference citation for that. Otherwise, it can be considered as a plagiarism, right? So ये सब हो रहा था. Then UGC they came into action and they had come up with the regulation. So in 538 meeting, which was held on 28 March 2018, considered and approved the UGC promotion of academic integrity and prevention of plagiarism in higher education HEI regulation 2018. This regulation has been notified in the official gazette of India on 31st July 2018. Objective of this UGC regulation: creating awareness, prevention of misconduct, establishing an institutional mechanism, promotion of academic integrity, prevention of plagiarism, setting up a system for catching plagiarism. So the objective of these regulations are creating awareness, prevention of misconduct, establishment and institutional establishment of institutional mechanism, promotion of academic integrity, prevention of plagiarism, and setting up a system for catching plagiarism. According to the regulation, what is the definition of plagiarism? So section 2, clause I define as a plagiarism means the practice of taking someone else's work or idea and passing them as own. So in UGC regulation, the definition is provide that plagiarism means practice of taking someone else's work or idea and passing them as own one. So this is called plagiarism definition. So UGC regulation code restricted to the HEI, higher education institutes, which are as follows: university, any institute declared by the parliament, any institute provides education after 12 of schooling and provides degree or diploma. So this is the scope of the UGC regulation. Of course, UGC regulation also define the script: research paper, thesis, study, project, report, assignment, dissertations, any other such work submitted for the assessment, right? But in the regulation, exam scripts are exempted. So if above are cover, it means you can there can be a possibility of plagiarism in research paper, thesis, study, project report, assignment, dissertation, and any other such work which is provided for the assessment or opinion for the award of degree. Only exam scripts is exempted. So HEI, what is the duties of HEI, Higher Education Institute? Establish a mechanism to hold sanitization seminar for student, faculty and other members, to create academic ethics, to provide academic ethics in the coursework for the undergraduate and postgraduate and master degree, to provide research and education ethics for coursework of PhD and MPhil, then to provide training for using plagiarism detection tools, to provide facilities for the detection of plagiarism. So what is UGC regulation exemption? In regulation, is there something exempted? Yes. If you are quoted properly, quoted work is exempted. All reference, table of content, preface, acknowledgement, and bibliography are exempted. Similar content which is minor are exempted. Standard equations and symbols, laws, and generic terms. These are all exempted in the regulation, UGC regulation. So, is there any zero tolerance policy? In regulation, they have provided zero tolerance policy in specific area of your submission. Which are the area? Your hypothesis, your recommendation, your abstract, your summary, your conclusion, your results, and your observation. In this area, the zero tolerance policy is there. According to UGC regulation, there should be no zero plagiarism in hypothesis, recommendations, abstract, summary, conclusion, results, and observation. So in the UGC regulation, they had plagiarism. So up to 10% is from 10% to 40%. Level 1 punishable. In between 40 to 60% level 2, and above 60% it is level 3. So how we have to detect and report? So according to UGC regulation, detection, reporting, and handling. First, you have to report to the DAP. What is that? Department Academic Integrity Panel, DAP. If when you report it, then DAP will investigate matter and it will recommendation will send it to the IAP, Institutional Academic Integrity Panel, and also take sumo notice of the act of plagiarism and initiate proceeding under this regulation. Similar proceeding can also initiated by the HEI on the basis of finding of the examiner. All such cases will be investigated by the IAP. It means there are three agencies. First one is HEI, second one is the Departmental Academic Integrity Panel, and the third one is that is called Institutional Academic Integrity Panel. All these three agencies play an important role in the UGC regulation. So what are the penalties? UGC regulation had mentioned the penalties. It is different for the PhD student and for the faculty. Up to 10% for student, no penalty. For faculty, no penalty. From 10 to 40%, student revision of script within 6 months. For faculty, has to withdraw the manuscript, right? Then 40 to 60% student can submit the revised script for 1 year. And from 40 to 60% for faculty, no supervision power for 2 years. Over 60% student cancel the registration. Over 60% for faculty, no supervision power for 3 years. So this is the way the UGC is punishing. This is the way the UGC is punishing. So if UGC regulation end of the HEI, if he is accused of plagiarism, then definitely the guideline had provided appropriate action shall be taken by the concerned authority. It means you are not going to run away. If you are the HEI, you have to also face the problem. So how to avoid? What are the three to four strategy how we can avoid? First one is quotation. You have to quote it properly. Second one is cite. You have to cite statistics, charts, graphs, and drawing. And the third one is paraphrasing, right? The fourth one is summarizing. You have to do the summarizing. We are in the copyright session, so we should know exact difference between the copyright versus plagiarism. Copyright is a legal term. Plagiarism is not a legal term. Copyright is a civil crime. Plagiarism is an academic crime. Copyright, unauthorized use of someone else's creative work. Plagiarism, claiming or appearing claim ownership of someone else's work. In copyright, monetary damages for infringement. In plagiarism, not punishable by the government, but maybe academic sanction. So this is the exact difference between this. So this is in the year 2020 when the lockdown is got active. So UGC had come up with a self algorithm dated 28th April 2020 that if you are doing self algorithm in terms of reproduction, text cycling or self algorithm without adequate citation and proper acknowledgement is not acceptable. If you are using your own words, you have to be quoted, you have to be acknowledged. Otherwise, it will be considered as a self algorithm. So after this, a long session, somebody will ask me the common question that is, do I cite everything? Except when you use your one, don't cite it. When the fact is in common knowledge, don't cite it. So this is my answer to those who are using asking me that question. Have to cite everything? So jokes for the session. The Bollywood and Hollywood. Bollywood is copying from the Hollywood. अबे दिखाना language change कर लूंगा. It means it's called as a plagiarism. It means it's called as a plagiarism. I will just talk something on the important judgments on the copyright. What are they? Rameshwar, photocopy. Very landmark judgment in the copyright. Delhi University plus Rameshwar. The three publishers filed the complaint against Delhi University and Rameshwar photocopy. The publishers are of Oxford, Cambridge, and Taylor and Francisco. They are selling the coursework back to the students. And at last, for the sake of the education, for the sake of the research, for the sake of the students, the publisher had withdrawn the case. But this is wrong. This is the infringement of the copyright. Then Amazon India, Apni Dukan. Yes, it was got in the copyright issue. The campaign was started by the Amazon India Apni Dukan. But when it is proved by Pune-based businessman Ravi Jain who registered Apni Dukan as a domain name back in 2007. So Amazon India had withdrawn that Apni Dukan campaign. Another important case, monkey selfie. Yes, Slater and Wikipedia, they got in the court. Slater was asking Wikipedia how to images which is owned by me. Then they had argued that it is Meta, people for the ethical treatment of animals. They sued the Slater in Monkey. That monkey name is Naruto in the suit to assert copyright. It doesn't come out, and they went for a settlement of the court. The Quetta lawyer said that 20% of the royalty of the photo will be given to the that Nota where he lives in that zoo for the benefit of the animals. India movement in the copyright. Yes, in March 1949, government in India, southern state of Tamil Nadu, acquired the work of one greatest poet. It was the first time in India, in the world, that the whole state had taken over the copyright of a writer and put his writing in the public domain. Then what about the famous writers who died? What about their copyright? Until it lapsed and passed into public domain in 2009. Sonia Gandhi holds the copyright to the Nehru work until 2024. Publisher had free access to the Nobel Prize winning poet Rabindranath Tagore's works only after 1992. Jokes. That beggar was singing and begging, "Hey Malik Tere Bande." That composer came and asked, "First pay my share of royalty, then only you will get the begging." So this is the way copyright can be protected. Right? So India initiated towards the IPR improvement. Yes, on 12th May 2016, India had come up with the intellectual IPR policy to extend the IP, to faster the IP process, reviewing rules and procedure, attract investment, make environment business friendly, and autonomy to the IPO. Even Indian government had established IPR cell in 41 universities across different states to organize group meeting lectures, to take IPR audit, to guide the inventors, to facilitate IP management. To conclude on the sessions, I will give you 3 tips. Protect your institution, faculty, staff, and users. What are the 3 tips with these 3 tips? Establish a campus-wide fair use policy, right? License for digital content. Read and negotiate license for digital content. Educate your campus, right? So this is the way you can avoid. See, I will conclude this session with the joke. It's nothing personal. We just like to secure our intellectual property each evening. It means you have to be very careful. You have to save your intellectual. Otherwise, somebody can come and take your intellectual. If there is any question, I am available for the question. Before that, I just want to thank Dr. P. Krishna Kumar, CEO and Secretary, MGA, Dr. P. Manilasam, Principal NIT, Dr. K.R. Senthil, coordinator and head librarian of NIT, and all the participants of the session. And this is my disclaimer: images and words are used for the education purpose only, so there is no copyright issue. And the said presentation is under copyright at the rate Prahlad Jadhav 2019. Thank you so much. If there are any questions, I am there, sir. Yes. Is there any question in the chat box? I'll just check. 12:10, na? Can an article that has been published be retracted after finding out by publisher that it was plagiarized? Does it mean that they didn't do plagiarism check on the article before publishing? Can an article that has been published be retracted? Yes. If yes, my answer is yes. If you find that there is a plagiarism and it is already published, then with a request you can withdraw that article from the publisher website or from the journal. It is better because if you don't withdraw and if you caught, then it will be a problem for you in your promotion, in your scale. Another question, I'll just check. 11. But a minute, I'm just checking. Yes. Faculty are asking us to scan the book chapter for the teaching learning purpose. How many pages can we scan from a book? If a chapter has been around 30 pages, is it fair to scan and share with them? Very frankly speaking with you, my dear friend, it is actually not allowed. But in Indian terms, under the fair use clause, we are doing such type of activities in the education institute. Agree, 20% of the books or 20% of that chapter. For example, if that chapter is carries 30 pages, then 20% is available allowed. And if that book is if you're talking about the book, then 20% is allowed. But under the fair use clause, you have to create your own fair use policy in your institute, and you have to circulate, you have to educate your people. This under the fair use you can do this and you can do that. So this is the actual solution for each one of us. We have to create our fair use policy, we have to create our institutional copyright policy, and we have to educate our teaching faculty and our students what they can do and what they can't do. So this is the way you can solve these queries. Out of print books are scanning and putting on institute library website. Any plagiarism, sir? Out of print books, of course, it is allowed you to do, but is only for the preservation purpose. If you are doing some commercial, then there will be a problem for you. If you are doing for the preservation purpose, it is allowed. It is allowed, sir. Anything else, sir?
Okay, sir. Hope everyone had cleared with their doubts. Once again, thank you so much, sir, for the enlightening session. Now, I call upon Dr. K.R. Senthil Kumar, Librarian, Nehru Institute of Engineering and Technology, to deliver vote of thanks.
Ja-
Thank you, sir.
Jadhav
Thank you
sir,
so
it's a
much.
nice session. Jadhav sir, it's a nice session for all of us. Thank you so much, sir.
Thank you, sir. Thank you so much. Sir, with your kind permission, can I leave, sir, now? Yes. Okay, sir. 1219. Can we download the books which are freely available over the internet and upload them on our personal Google Drive and circulate the link with the users of the library? Friends, so Mr. Sumit, just one suggestion to you. Definitely, there is a misconception about the web information. Sometimes the information which is freely available on the web, it may be copyright. You have to be very careful. See, if that book is not under the copyright, if it is under public use, then definitely you can do. But if that author is made publicly, and if you're doing this activity for your user, then there is a copyright infringement. You need to take the permission. If that books comes under the copyright, you need to take the permission. If that books doesn't come under the copyright, then you can directly upload. There is no issue to you. Yes. So it takes a lot of efforts to make. I can't share the PPT, but definitely if you want, I will share summary of my presentation with you. But for that, I will request you some more time from you. Thank you so much, sir. With the director sir's permission and Senthil Kumar sir permission, can I leave, sir, now? Thank you, sir. Thank you so much. Sure, sir. Sure.